We might as well get started, and I will. I can do some basic introductory stuff, and then I'll get right into the comments on getting back to business, which is kind of the stage we're at. For those of you who don't know me, my name is Steve Seiferling. I am a lawyer that practices exclusively in the areas of labor and employment in Saskatoon. We do work throughout the province of Saskatchewan, but we also advise a little bit on other provinces, and we advise in all the areas that are covered by labor and employment. So that includes occupational health and safety and human rights and construction labor relations. And we work a lot with all sizes of business. We generally represent the employer side rather than the employee side. We are the first labor and employment boutique in Saskatchewan, and we are and we cover off pretty much all of the issues that come up. So, and I want to thank the Manic Group for having me here today. This is I think these are essential. These types of seminars are essential in this time, so that we can get some of the basic information out there. Now, for those of you who just joined in the last couple of minutes, I'm encouraging you to ask questions throughout the seminar. And I encourage you to ask questions as they come up. Rather than waiting till the end. I don't need you to wait till the end. If you've got a question or a pressing issue that you're dealing with, I'm happy to answer it as we go through this seminar. You don't have to wait. So the main thing I wanted to talk about today is is returning to business, and I won't say returning to normal, because normal is still a ways off. And for some businesses, it's not going to be possible to return to the same state they were in before COVID hit. So we're dealing with something very different, and there's kind of three stages to the triage that we deal with as far as dealing with the pandemic. The first one was dealing with the layoffs and the leaves that we had at the beginning, and some are still dealing with those as business declines or adjusts to the realities that we're living with right now. But I will go through the basics of the layoff versus the leave that we've created in Saskatchewan. But the reality is that some businesses are starting to open up again, and our province is permitting others to open up again with certain precautions in place. And what I want to talk about are some of the issues that might come up as you reopen your business, or as you bring more and more people back to work. Now, before I go into that, I'm going to go very quickly through the layoff and the leave that were created in Saskatchewan, and I'm also going to go through the federal and provincial government programs that are directed to employers, not the ones that are directed to the employees, where we've got lots of those. I'm focusing on the programs that were directed to employers. And then I will go through, and then I'll get into the returns to work. So just very basically, what our province did, what the province of Saskatchewan did when the pandemic hit, was they created two different rights for employers. One was the right to lay off on a temporary basis without notice or pay in lieu of notice. So no severance, no notice. You could lay people off for a period of 12 weeks in a 16-week period. So that is effectively 3 out of every 4 months. You can lay the employees off as long as the state of emergency persists. Now, I don't see the state of emergency going away anytime soon, but that 3-month period is going to start expiring for some businesses relatively soon. So there will be some return to work issues if you haven't managed it. What you could have done right from the beginning is had a 3-week off, 1 week on rotation, assuming that your business was actually permitted to open. You could have done a 3-week off, 1 week on rotation, which would have allowed you to take the benefit of the layoff provisions at the same time as continuing to operate the business. Now, the reality was that some businesses were ordered closed, and the businesses that were ordered closed are protected by the other branch, which is a leave. It's the public health emergency leave, once again triggered by the state of emergency for the province, and clearly covering any business that is forced to close. There are other options within that leave. An employer can send employees home if they during the state of emergency, to prevent or reduce the spread of the pandemic, of the illness, and they can be sent home by order of a doctor or by order of the chief medical health officer of the province. Chief medical health officer is the one that's ordered the closures, working with the province. So those are the ones that are covered off there. The other distinct feature of the leave is if you're a parent who has lost their child care as a result of COVID, you are able to go on the leave. And both the leave and the layoff are without pay. Unless you authorize the employees to work from home, both the leave and the layoff are without pay. So you don't have to pay them to stay home. You don't have to pay your employees to stay home unless you choose to do so, and unless they're able to work from home. So if you're authorizing them to work from home, you do have to pay them. With respect to childcare, if somebody has a parenting obligation and they've lost their childcare as a result of COVID, they're able to take that leave themselves, the public health leave themselves, and stay home to care for their child. So that covers off, that is the only situation where the employee would dictate that they're going to stay home. All the rest of them are employer controlled. So, and you would have to accommodate that and deal with it if an employee comes to you with that situation. Now, the government has responded. The initial government response, both on the federal and the provincial level, was how do we protect the employees? And they created a bunch of programs, and I'm sure you're familiar with many, if not all of them, that would compensate the employees while they are laid off or while they are required to stay home due to business closure. And then they realized, well, we're not really providing anything for the employers. The initial proposal for the wage subsidy was a 10% subsidy, and that really didn't cover off a lot of the issues that most of the employers were suffering. So what they did on both the federal and provincial level is they've created, well, in my view, at least 4 categories that businesses can use to help subsidize during this time. The first one is the wage subsidy. So the Canada Emergency Wage Subsidy is available to employers who have suffered a 15% loss in revenues in March or a 30% loss in revenues in April. And that's measured on a year-over-year basis or compared to January and February. If you want more information on that, we can provide more information, or you can talk to your accountant. This is a wage subsidy of up to 75% to a maximum. So it maxes out when somebody's making about $58,000. They'll pay up to 75% of of that person's wages, and that goes directly to the employer. This is for employers with a payroll of between 20,000 and 1.5 million, and they have to show those reductions that apply. Those same criteria, the 20,000 to 1.5 million, also apply to the interest-free small business loan, those criteria only apply to the small business loan, the 20,000 to 1.5 million. The wage subsidy was expanded to include even the large businesses. So if you qualify as far as the 15% and the 30%, and you have to reapply every month, it is worthwhile to try and get some compensation for your employees. And that is one of the things that you can look at as you're bringing them back, to subsidize some of the wages and to take the effect of this at least temporary closure, reduce it for the business. Now, For the interest-free loan, it is a $40,000 loan, 10,000 forgivable, interest-free, and it is the 10,000 is forgivable as long as you paid at least 30,000 of it back by the end of 2021. So you have lots of time to pay it back. It's a very simple application process, and there are no revenue or other targets. The only thing is the requirement that you need to be between 20,000 and 1.5 million of annual payroll. And there's been some questions about what annual payroll means. Generally means employees. It doesn't count independent contractors and doesn't count owner employees for the most part. But once again, you can talk to us or talk to your accountant if you're wondering about that one. The Saskatchewan Small Business Grant is another one. It is a one-time payment of $5,000. That one's relatively simple to apply for. You just have to show that you've been in business for a certain period of time and you have less than 5,000 employees, or 500 employees, not 5,000. And you're operating in the province of Saskatchewan. One-time payment of $5,000. That one, and that is not a loan. That is a one-time payment. So that's a grant. You can apply for that one quite easily online. And then the final one is the rent subsidy. The federal government has worked with the provinces to create this rent subsidy. Now, the downside of the rent subsidy is it's applied for by the landlords, and it doesn't cover all of the rent. The criteria for that one is you need to show a 70% decline in your revenues, or you need to have been required to close. Now, it is incumbent on the landlord and not on the person leasing from the landlord to apply for that one. So if you think you might qualify, or if you're dealing with a business that is closed and you're struggling with rent payments, I would work with your landlord and try and encourage the landlord to apply for the subsidy. They receive the payment of 75% of the rent from the federal government, and it is paid directly to the landlord, and the 25% is supposed to still be paid by the renter, by the lessee, but the most landlords are willing to sit down and talk with you about whether or not you can afford that. And for some of the businesses that have closed, I know that landlords have waived that other 25% when they have applied for the subsidy. All right, let's talk about the main thing that we wanted to discuss today, and that is returning people to work. So as we come off of these layoffs, as we come off of the closures and layoffs in the next couple of weeks, and we've already seen a little bit with some of the procedures and some of the medical system opening back up to a greater extent. But next week, next Tuesday in Saskatchewan is going to be a day where retail businesses and some other limited businesses will be able to open back up. We're not at the level where restaurants are opening yet. We're not at the level where fitness centers are opening yet. But we will have some limited retail businesses and aesthetics businesses opening back up next week. And for those, there are distancing requirements, there are safety and protective requirements that are coming into play, which might mean that you can only bring some but not all of your workers back. And for some of these businesses, yes, you'll be dealing with independent contractors, but for a lot of them, you're going to be dealing with employees. So what we're going to look at as far as bringing the employees back is making sure that we are preserving the layoff rights that the government has created, and not preserving the layoff rights. Now, for the businesses that have been ordered to close, they are working under the leave provisions. So what you want to do if you are dealing with one of those businesses, or if you own one of those businesses, they've operated under the public health emergency leave because they've been ordered to close. At this point, if you are not able to bring all of your employees back, you may want to send off a layoff notice, a temporary layoff notice, or a rotating layoff notice, advising the employees that I'm going to have you work 1 week on, 1 week off, or I'm going to have you work on a rotating schedule where you are preserving your right to your rights under the layoff provisions, and you're able to more gradually return the people to work, where you're not able to return everybody at the same time. And that's just going to be the reality of it for a little while. We're not going to be able to return everybody to work at the same time. If you look at the restrictions that are being placed on the salons and even the stuff that's already in place with some of the paramedical providers like chiropractors and massage therapists, those services or massages next week, chiropractors are already back open. The restrictions that are being placed on them require extra time between clients and extra protections and face masks and a number of other things. With the distancing rules, you might not be able to have everybody back at the same time. So I would strongly advise you to look at what are my options for rotating workers or rotating layoffs. That is one of the issues that is going to come up, and that unless you are a true part-time business where you would be able to schedule them week on, week off, that'll help you manage that'll help you manage your costs and the burdens of bringing everybody back. Now, and if you are truly part-time, or if you're managing that way, the employees, any employee who's still making less than $1,000 a month when they return, remains eligible for CERB, for the Canada Emergency Response Benefit that's administered through the Canada Revenue Agency and Employment Insurance Service Canada. So if they're making less than $1,000 a month, they still get to collect the additional $2,000 from the government for CERB, as long as that program remains active. So if that's a concern, you might work with your employees to make sure that they are making less than the $1,000 a month. Sorry about that. That's my phone ringing in the background. The other issue is what happens if I am not able to bring everybody back, and I know already that some of my reductions are going to be permanent. So the government has clearly distinguished between temporary, due to COVID, reductions and permanent reductions. The moment you make a decision that a reduction becomes permanent, you fall back under the severance and or notice requirements set out in the law. So you would be at that point, as soon as a position is going to be permanently removed, or if you go past the 3 months, the 12 weeks and a 16-week period, then the layoff becomes permanent. And at that point, your obligation to pay severance or to give working notice is going to be triggered. You need to be aware of that, because and the law has been pretty strict on this. If you went a day over the 3 weeks, you could end up with a permanent layoff, and then you've got to be careful about triggering that severance obligation. So that's one of the factors that we can look at. As far as the gradual opening goes, as you're bringing employees back, the wage subsidy is available for the wage subsidy that I talked about is available for businesses that can show that reduction in revenues. If you can show that, I would use that as a supplement to bring your employees back. Because if anybody's going to pay me up to 75% of my employees' wages, and I can show that I've got the diminished revenues. Now, the disadvantage of the wage subsidy is that it only applies to active employees. So the employees would have to be coming off of EI or CERB or whatever program they happen to be on, and they'd have to return to an active status, but then they would collect that amount. Now, one of the questions that has come up repeatedly is, well, if I'm getting 75% of their wage from government, do I have to pay them the other 25? The answer is that you're encouraged to pay them the other 25%. And there is a small chance that your employee would say, well, if you're cutting my wages by 25%, then I consider that to be constructive dismissal. Constructive dismissal is a situation where you've made a material change to working conditions that goes to the heart of the working relationship. If you're going to pay them just the 75%, I would make sure that you make it very clear that it's being paid on a temporary basis and not a full-time basis, and that they will return to their usual or their regular wage at the end of the state of emergency, or at the end of the supplementary period for that wage. Now, if you're looking to do a permanent reduction in wages, or which is the other option, I know a lot of employers are looking at, well, how do I reduce my wages rather than laying people off? I'd rather have everybody take a 10 or a 20% wage cut and then have to lay anybody off. The risk that you're taking if you do that, you can do it. The risk that you're taking if you do that is that one of the employees or a group of the employees will say, no, we believe that is constructive dismissal, and which another way of describing constructive dismissal is quitting for cause. So they would leave the organization. They say, you know, you've materially changed the terms and conditions of my workplace by reducing my wage on a permanent basis, and therefore I'm leaving. I'm quitting for cause, and you're going to have to pay me out some severance. I don't see that as a huge risk at this point, because of the nature of the pandemic and the fact that we've had significant effects on our economy. These cost-cutting measures are going to need to be in place for a lot of businesses, and it's going to be the option of either permanently reducing the total number of workers or trying to manage costs. So you can do it. The best way to do it is to talk to your workers, and if you are going to do a reduction, I try to keep it as uniform as possible or as consistent as possible, where everybody in the organization is dealing with the same type of a cut. Because if you're picking and choosing, then that strengthens the argument for a constructive dismissal case. Now, the other issue that does tend to come up is the employee. There's two situations here. One is the employee who says, I'm refusing to come back because I'm worried about COVID. The other one is the employee who says, I am refusing to come back to work because I am more efficient working at home or working from home. And they're different situations, but you'll be happy to know that most of that is at the discretion of the employer. Now, the I'm scared to come back because of COVID. The protections that are in place under the Saskatchewan Employment Act do allow an employee to refuse work that they have a subjective belief, so an individual belief, is unusually dangerous. Now, that can be overcome by dealing through your occupational health representative if you're a company with less than 10 people, or your occupational health committee for a company of 10 or more. And you can refer that refusal to your occupational. The first step is to talk to the employee and say, what are you concerned about? And you try and address their concerns with them and tell them, okay, well, you're going to return to work. Here are the conditions, here are the safety protections we're going to put in place to make sure that you're able to safely return to work. If you're not able to deal with the employee, then you refer this to the occupational health representative or the occupational health committee. And they are supposed to do an objective analysis of whether or not the work is actually unusually dangerous. And with all of the protections that are being put in place and recommended by government, you have a very strong argument that as long as you're following those recommendations and protections, the work is not unusually dangerous, because these are the protections that have been dictated by the Chief Medical Health Officer for the province. So dealing with those types of refusals is generally going to be easy and efficient. Now, there is another level of appeal. So if the Occupational Health Committee comes back and says, no, it's not unusually dangerous, the employee can go all the way to the to Occupational Health and Safety Saskatchewan, WorkSafe Saskatchewan, and they can file an appeal there of the Occupational Health Committee's decision. Those cases are pretty few and far between. Most of them get resolved at the employer-employee level with just a simple discussion. But we will see there, I know we've already seen, and we will continue to see, a number of people who are refusing to work or to return to work due to COVID. And the second category, and this might be a joint category with the first, because some of them have concerns about returning to work due to COVID, and they also believe that they are working more efficiently from home. Now, whether or not you work more efficiently from home, it is going to be within the employer's discretion to decide where they want you to work. So if you as an employer say to your employees, I need you to come into the office, and some jobs need to be done at the office. You cannot accomplish some work from home. Now, if you want to do the evaluation, I know that there are some people out there who are a lot more effective from home. But they are required to be in the office so that they can interact with the other people in the workplace. Lawyers are a good example. If you've got an in-house lawyer who is dealing with general problems in the workplace, it's a lot easier to walk down the hall and talk to that person than it is to try and contact them via email or pick up the phone, especially if you've got just a quick question, even if they are more effective at dealing with some issues from home. But it is going to be within the employer's discretion to determine where the person is going to be situated for work. Now, if an employee insists on working from home and refuses to come into the office on the basis that they believe that they're more effective from home, that's a resignation. And what you would do is you confirm that resignation in writing, or you would send a letter to that employee saying, you need to be in the office next month, or Monday's a holiday. You need to be in the office on Tuesday the 19th and report for work. Otherwise, we will consider you to have resigned your position with our company. And then it's up to them to respond and determine whether or not they're going to try and hold their ground and convince you that they can work from home. Now, it's worth having a discussion about whether or not it's more efficient and more cost effective to have some employees work from home. I know if you could eliminate your need for office space or reduce your need for office space, you could reduce your operating costs. But in a lot of businesses and a lot of professions, it is a challenge to have remote workers, at least for the majority of the positions. So those are the two big ones that we tend to deal with employees and refusals. And I already talked about the constructive dismissal issues a little bit. The constructive dismissal issues that do tend to come up. The big one is wages, always. So what we look at for wages is an employee saying, well, you've cut my wages and so I'm quitting because you've made a material change to my employment contract. This is not what we agreed upon when I signed on to work with you guys, and therefore I'm quitting, and I'm going to go after you, and I'm going to claim severance. Now, if you have targeted one employee and just reduced their wages, then they'd have a good case. But given the global pandemic and given the overall situation, right now, as long as you are doing reductions across the board, relatively consistent reductions across the board, and requiring everybody to deal with the issue and to absorb a bit of a hit, then the courts are not going to look poorly on that, because and if you've got a way to communicate with the employees, I would do that. I'd communicate with them directly and say, here is what we're facing. We're either going to be doing reductions, where somebody is going to be permanently laid off from their job, or we are going to ask everybody to take a pay cut so that we can continue to operate as we've operated in the past. and you involve them to some extent in the decision-making process. The ultimate decision is going to be the employer's, but if you involve the employees in the process and say, you know, would you prefer that we laid people off, or would you prefer that that everybody takes a cut? Then they've got some buy-in, and that can be an effective tool for managing employees in the workplace. Now, the last area, or I guess the next to last area that I want to cover is the unfortunate reality of permanent reductions and closures. We are already getting questions, and we've already seen some businesses saying they're not going to reopen. As early as March, when the pandemic hit, I think the numbers then were around a third of businesses that were being surveyed were saying that they were gonna struggle to reopen. I know that some more recent studies and surveys have said 40 or 45% of businesses are going to struggle to reopen or not be able to reopen at the end of May. That is the reality. We are going to lose businesses, especially in the industries where they've been required to close. If you look at the restaurants and the gyms and a number of the others, it's unless you're operating out of your home, you're going to be there is a current struggle to manage your costs and everything else. Even if you've been able to lay people off, the costs of leasing property and of equipment and of everything else, those go on. And so the unfortunate circumstance is that some businesses are not going to be able to reopen, or some are going to have permanent reductions in workforce. And if you're not able to deal with the employees by saying, okay, everybody takes a pay cut, then you might have to make the tough decision to lay off one or more employees. And that's, once we've got that decision made, and I've already talked a little bit about this, but once you've got that decision made that you're going to lay off one or more employees, then you're into the standard process for layoffs and severance. So you'd be dealing with either giving them working notice or pay in lieu of notice. Now there's two categories there. One is the minimums that are set out under the Saskatchewan Employment Act. And those range from 0 for less than 3 months of employment all the way up to 8 weeks for 10 years or more. That is not what you end up paying. And even if you're doing working notice, that is not what you would end up dealing with. A business will be, could be subject to, unless you've got restrictions in a collective agreement or in an employment contract, you would be subject to paying higher amounts, which we call common law notice. And common law notice depends on a number of factors, including the length of service with the employer, including the age of the person who you are laying off, the seniority of the position they occupy, and the availability of similar work. Now, that last factor, the main factor that the courts look at right now is still the length of employment. But the last factor, the availability of similar work, is going to be a huge factor for the people who are permanently laid off as a result of COVID. We're already seeing record unemployment numbers around the world, including in Canada, and there is just no work available. There are very few businesses who are hiring right now of the ones that are still operating. And the businesses that are going to be coming back online or forced to make a decision on closure are not going to be in the same category as the ones who have continued to operate throughout this. There's some businesses that throughout the pandemic have actually seen increased business, but those are the more essential businesses like the grocery stores and the supply chain folks. Construction has seen a bit of a hit. We're not seeing any new projects. Most of the industries have seen quite a hit. So in most industries, if not all industries, there are people who have already used the temporary layoff or the public health leave provisions, and there are also people who are who are struggling with, am I going to be able to bring everybody back? So the difference between a closure and a permanent reduction of staff is that you are obviously that you're continuing to operate, but there would be some extra hoops you'd have to jump through with respect to closing and wrapping up a business. And I'm not going to go into the details of those here, but if you are in that situation, you would be wise to contact somebody who has knowledge of corporate law and winding up, and possibly even bankruptcy and insolvency law. I will give you the specifics of how to manage both these, the permanent reductions and the closures, from a labor and employment perspective. So from a labor and employment perspective, you are dealing with permanent reductions, and so you would be on the hook for the wages up to the last day worked, if the person is continuing to work right now, as well as either notice or pay in lieu. And what we generally do is we cover, if you're going to give them working notice, you give them a longer term of working notice. And it can be a combination of those two as well. You could use a combination of working notice and pay in lieu of notice, depending on the nature of the business, to allow the person to continue to work for a bit, and then give them a payout afterwards. Now, the range is, like I said, is dependent on those four factors, but it also takes into account if and when the person finds other work. So assuming that they find other work, if you lay off an employee who's got 10 plus years of service and they hold a relatively senior position within your company, but they find work within a couple of months, then you're only necessarily on the hook for those 2 months to bridge that gap between laying them off and them finding other work. And there's ways to manage that with the termination and the severance offer. The legal term for it is mitigation. So they have a duty to mitigate when they're let go, and to search for and accept other work. And if they fail to do that, there's a reduction in the severance amount. Or if they completely mitigate, if they find another job in 2 weeks and they're making the same or more, then you're off the hook for a lot of the costs that would be incurred. Now, these numbers can be big. A long service employee, the cap in Canada for common law notice, which would include the statutory payment of 8 weeks, is 24 months. So you're looking at, and this is for the very long service employees, you could be looking at a payment of up to 2 years. Now, there's ways to manage that through mitigation and through everything else, but that is the potential exposure. Now, you might be saying, well, okay, if my business is going to close, then would I actually be on the hook for the common law notice? The answer is yes. The business would still be on the hook for common law notice. Now, if you go into the bankruptcy or insolvency proceedings, then they become a creditor as well. But there is a specific section in the Saskatchewan Employment Act saying that your directors, your corporate directors, are personally liable for wages. Wages include the severance amounts, arguably including the common law severance amount. So your corporate directors need to know, even if you've got a waiver of director liability, your corporate directors need to know that they could be on the hook for wages in the event that the business is closing. And that would be one of the differences between a closure and a permanent reduction. Permanent reduction, your business continues to operate as a going concern, and you've got the wages paid as a liability of the company. If you close up, then the directors could be on the hook. Your corporate directors could be on the hook for any wages that were accrued while they were a director of the company. Now, I'll leave that to you to decipher what that might mean for directors resigning from your company if you are in the unfortunate situation of considering a closure. But and yeah, they could be on the hook for any wages accruing while they are a director of the company, and we do need to flag that. So now, one of the things that you can do if you're on the brink of a closure, or if you're trying to manage these situations, is you can combine everything that I've talked about today. And the way to do that is the layoff provisions are very useful if you're opening up at some capacity but not a full capacity. So you can do these rolling or rotating layoffs, which allow you to continue to operate at a reduced capacity and prevent you from having to permanently lay off and end up on the hook for severance for a number of your employees. So if you are able to manage that and schedule that with the rotating layoffs, then that is a much better way to manage it. The other tool that our governments have provided us with is the wage subsidy. So one of the options with the wage subsidy might even be to say, okay, well, I don't need you at work on a full-time basis right now because of the nature of the protections and the safety issues that we've got to abide by for the workplace. But I want to return you to active status. So I'm going to return you to active status, and I am going to file an application for the Canada Wage Subsidy. And you're going to be paid 75% of your normal wage up to the maximum. I think it's $8.90 a week. That's the number that sticks in my mind. Up to the maximum of $8.90 a week. You're going to be paid 75% of your wage, but we're not going to have you work all the time. We're going to have you work on a more temporary schedule or a more intermittent schedule on a temporary basis until we're back up to being allowed to run full time without these restrictions, without the safety protections. We're going to have you work on a more restricted or a more intermittent schedule, but we're going to pay you the 75%, assuming that we get it from government. That also puts you in a situation where the employee is back on an active status. You're not requiring them to work full time, but they are getting paid the up to 75% that the government is subsidizing. Now that wage subsidy, I think it's extended into June now, but I wouldn't be surprised if it extends further, if it gets extended further. So if that is an option for you, if that's a reality for you, then that is something that I would seriously consider, because really we want to avoid the closures and the permanent reductions if at all possible, because that's where the costs tend to balloon. That's where the costs tend to go way up of reducing or managing the employees. Now, different considerations would apply if you're in a unionized workplace or if you've got a workplace that's been unionized, and you may have limited your liability if you've got specific employment contracts with specific termination provisions. So you'd want to look at those or have somebody look at those if you're in that situation. But the overall message is that you want to try and keep the employees as active employees if at all possible to avoid those costs of permanent reductions or closures. So I know I've got about 15 minutes left, and I haven't seen any questions on here, or haven't had anybody unmute themselves and ask any questions. But if there's anything that comes up, or I guess I'll ask right now if there's any questions. If not, I'll go through a quick summary of or a quick recap of everything that I've covered.
So anyone can feel free to unmute yourself or type your question in the chat. I do have one question that came through in a private chat. And okay. So they were asking, what if an employee was moved into a new role and wants to stay there? Am I obligated to offer that position to them permanently?
No. Yeah, the short answer is no. You are not obligated to offer that position to them permanently. Now, if it is a position that is going to continue to exist, then ideally, you would have told them at the beginning that that the role that they were occupying was a role that they were occupying on a temporary basis. But regardless of whether you specifically told them that, you are always going to be able to make decisions about the workplace. And that can include assigning duties, that can be assigning titles, assigning roles. The only risk there, once again, this is the constructive dismissal argument. And I don't see it as a huge risk right now because of the global situation. Normally, if you were changing titles or changing responsibilities, there is a risk that somebody would go into that constructive dismissal mode and say, I'm quitting for cause. I believe that you've changed my job in such a material way that that it goes to the heart of the employment relationship. I believe that's the language that's used in the court cases. And most of those cases deal with reduction in wage or reduction in duties or obligations. And by duties or obligations, I mean, some of the cases have talked about where somebody is a salesperson and their territory. So their base wage isn't reduced, but their territory is reduced. So their earning potential is reduced. Usually these are dealing with money. There's occasional cases that don't deal with money, that deal with titles or assignment of work. But the risk of a constructive dismissal claim at this point, given COVID and given everything else, and given that people want to stay securely employed, is very minimal. So the answer is yes, I would move them back to the position that they were in prior to COVID, and I don't see much risk, if any, in doing that. As the employer, you're going to be able to assign the jobs, and you need to decide what is best for the workplace. They don't get to decide that. It's just like the situation where the employee says, I'm more effective from home. Well, that's great, but we believe that we need you in the office. That's a decision that the employer gets to make.
Perfect, thank you. In the same chat, the question came up of, can I reduce the number of hours and pay permanently after my employees return to work?
That's, once again, that's the only risk there is the constructive dismissal risk. And a business that's not going to be able to operate unless things are reduced permanently, I would do it. I would recommend that you do the reductions on a permanent basis. And I mean, you can always reassess in a year. If business is going good, then you can reassess whether the reductions are permanent, or if there's going to be a slight increase to get them closer to normal, closer to what they're making now. The only risk there is the constructive dismissal. So you may have one or two employees, or even a group of employees, that say, no, we refuse to accept the jobs under a reduced rate, and so we're going to go and look for something else, and we're quitting, and we believe we have cause to quit because you've reduced our rates. I don't think those arguments are going to hold a lot of water in front of the courts, given the global situation. I could be proven wrong, but I don't think the courts are going to look at that and say, well, you know, this business made some decisions to survive and to continue to operate as a business, and it made a decision to permanently reduce some wages rather than either closing up or rather than permanently reducing the number of people. So I don't think a court is going to look poorly on that. And so I don't see that as a huge risk in doing the permanent reductions. Once again, as long as you're consistent. If you're targeting one person or targeting a small group of people within an organization, and you're saying only you will be taking reductions, that makes for a stronger constructive dismissal argument. So as long as you're doing it consistently with everybody, and I try and discuss it a little bit. Well, the ultimate decision is the employer's. I try and discuss it a little bit with the employees before you do something like that, and see if you can get their input and feedback on, would you prefer if I did some permanent reductions, or would you prefer if I did if everybody accepted a reduced rate? And the employees, with the exception of the ones who believe that they're going to be the ones held on if you do some reductions, most of them are going to say, well, I'll take a pay cut as long as I keep my employment. So the short answer is there's a risk there, but I don't consider it a very material risk as long as you're consistent.
Awesome, thank you. That's everything on my end. If there's any other questions, feel free to write it. Oh, in the chat, there you go, you have one. As an employee, is there anything that can be done to keep jobs? Well, the reality is some businesses are going to close. But if you're an employee, I'd go to your employer and say, you know, are we going to manage through this, and what needs to be done to make sure that we can keep everybody or almost everybody around? The conversation can be initiated at both ends. It doesn't have to be the employer that steps up and says, okay, well, what do we need to do to continue to operate? And if we're going to do something like a wage reduction or a reduced rate or reduced working hours or some kind of adjustment in the workplace, is it going to be temporary or permanent? And can we put it in writing? If I'm coming at it from the employee side, I would say, well, we'd prefer if this was temporary, and we'd prefer if this was in writing. So can we write it down and say, you know, we'll agree to a 3-month, 25% reduction in wages as long as the employer tells us that it's going to go back up 25% in 3 months. Now, if I'm approaching that from the employer side, what I'd say is, no, we're going to do a 25% reduction in wages, and we're going to assess as time goes by to see whether or not we can bring that back up. So depending on what approach, what side you're taking, what perspective you're taking, the key is to initiate that conversation and to make sure that the business is going to survive. We're already giving opinions. The office has already given opinions on business closures, and I'm sad to see them, and I hope they are minimized. I think our province has been fairly progressive in opening things back up, which I'm very happy about, while still considering the seriousness of the pandemic. So I'm somewhat optimistic that a lot of businesses will survive, but I already know that there are a number of long-standing businesses that are not coming out of this. So the sooner that conversation is initiated, and the use of those tools like the rotating layoffs, the use of and rotating layoffs so that the employees can stay on CERB if at all possible, and use of the wage subsidy if you qualify for it. Even though $5,000 one-time payment is helpful for a lot of businesses, and that the interest-free loan. I mean, the interest-free loan of $40,000 with $10,000 forgivable, that's $10,000 of free money as long as you pay it back. So those programs can be beneficial. There's more that could be done. I mean, saying you need a 70% reduction and it's incumbent on the landlord to apply for the rent subsidy. Some people have complained, well, that's not enough because the rental cost is my big cost. But taking advantage of those and managing your way through it is the best way through this. And hopefully all of the businesses are able to survive and manage their way through it. And for the most part, the employees have been more than willing to work with the employer to make sure that the business succeeds. They'd rather have a job in 6 months than be permanently laid off. So just my opinion, but I don't see constructive dismissal as a huge risk. I know it's been raised by a number of my colleagues across Canada as one of the biggest issues coming out of this. I don't see it as big of a risk in Saskatchewan, just given the nature of COVID. I think of something like, you always treat these cases based on the facts, and presenting the facts like that to a judge, as long as the employer's been consistent, presenting that to a judge is quite a sympathetic situation. So I'm not that concerned about the constructive dismissal issues. Any other questions? We got a few minutes left, but that's it for now. So people can continue.
Can I ask one question? Sorry, it's
yeah,
Kara.
go ahead.
I guess I'm just wondering how, I mean, maybe you can't even answer this, but just like, essentially the waves of business, right? So for instance, some, like I'm in rehab, and so in the rehabilitative sector, and so, you know, they're saying, okay, like you're a part of phase one, but then if primarily your contracts, let's say, are with schools or something, you're coming into slow time, so your May and June might kind of look okay, even though schools aren't back in, right? Like it's just, you know, in talking with our landlords, and we've been really fortunate, but I guess just handling the waves, like May might be okay, but July could be dead. And then the fall, give or take, I mean, with the university not going back in, like there's still a lot of unknowns, but I guess just handling the waves of it all, and what qualifies and what doesn't, like if there's any kind of.
That's a good question, because a lot of business is cyclical or seasonal,
Yeah.
and so a lot of the businesses, and construction is one of them. Normally, construction is ramping up heavily for a busy season right now, and a lot of the projects are suspended or on hold right now, simply because of the pandemic. So a lot of the construction industry businesses are saying, well, where is my money going to come from this summer? Where is my revenue going to come from this summer? And the key is managing the way through that. I mean, if I had to guess, I'd say phase 3 is probably going to happen sometime in June, and which will be, assuming no hiccups in phase 2 starting next week. We will see. My guess is we'll see phase 3 sometime in June, which would mean that restaurants and fitness facilities and other businesses would be able to open up on a restricted basis. Once those supplementary services are back open, I think you'll see some of the other businesses, some of the other work start to flow again. And one of the things that Kara's question actually leads to, and I'll close with this, is that although government hasn't really closed anything, the government of Saskatchewan hasn't really closed anything. They've got a number of their employees working at home, and they do employ a number of the essential services folks. They have terminated pretty much all of their contracts. So all of the independent contracts that they were entered into, they terminated either on the basis of force majeure or on the basis of COVID. And so those are still up in the air. And as long as we start seeing a recovery here, and as long as the phase 2 and assuming phase 3 goes ahead in June start going smoother, we might start seeing those contracts come back online. That also helps the economy. That also helps with managing the workflow and increasing business in a number of sectors. So and a lot of businesses are suffering because the government has pulled all those contracts at this point. And schools are another one. If with the schools being online in the fall, U of S at least being online in the fall, I've got to figure out how to teach my class online. But the challenges, the continuing challenges of that, if we've got if the elementary and the high schools come back to us and say, well, we're going online too, how are parents going to manage that? It's going to be a huge challenge, and that will cause a greater hit to our economy, I think, than some of the other factors that we've talked about. But hopefully this has been helpfully for everybody. Hopefully it's answered some questions, or maybe even raised some questions in your minds. If you want to, feel free to email me. I believe my contact information is up on the seminar page. Feel free to email me with any questions that came out of this, even if you didn't want to ask them in the big group. We're happy to help out, and I've got a good team of people who's able to assist, even if I'm not directly available. So thank you for having me. Thank you to Manik for having me, and I'm happy to participate in these types of conversations.
Well, thank you, Stephen. You know what? It was my mom who reached out to you. Kanchan reached out to you, and she said to me that when she did reach out, you were just so quick to accept this webinar to help everyone out. So thank you for that. And yes, we will absolutely keep your contact information available for anyone. If you have any questions, you've been really fantastic about helping to support all of our program participants. So really, really do appreciate your time today and your offer for help in the future as well. So really appreciate that. Thank you. And thank you to everybody who has participated today and asked questions. Just so you know, our next webinar is going to be next Thursday, May 22nd, with Daniel Jamil. He is the founder of Ooh La La Mobile and 2015 Forbes 30 Under 30. He was our keynote in 2018. So he's hosting an open discussion, taking questions, challenges, fears, and just having that, answering all of those questions for you and hosting that open discussion. So you can feel free to send your questions in via email to info@manicmentorship.sk.ca. We'll get those over to Daniel ahead of time so that he's prepared and can facilitate that, that discussion. But we're really excited to have him. So that's next Thursday, May 22nd at noon. But in the meantime, thank you so much, Stephen. Really appreciate your time today.
My pleasure.
Awesome. All right. Have a great
day, everybody.